welcome to Wealth Matters, where we discuss the opportunities and challenges of preserving and managing wealth. We are broadcasting today via remote access, so that in light of the COVID-19 health emergency, we can maintain our social distancing and still bring you today's show. Please be patient if we experience any technical glitches. We hope that everyone listening is safe and healthy and doing what they can to protect themselves and our communities during this health emergency. Wealth Matters is presented to you by Frankel, a law firm dedicated to resolving disputes involving your wealth, whether your will, your trust, your business, or your investments. For news, pictures, and tips, go to our website at gasowiczfrankel.com or follow us on Twitter at Estate Dispute. Our show's hashtag is Wealth Matters. Your hosts today are Craig Frankel, and welcoming for the first time in Wealth Matters, my partner, Leanne Gilbert. Today, we're talking about financial planning in today's unpredictable world.
Thanks, Craig. And it's time to introduce our guests today. We're pleased to have Christopher Shukri, a financial advisor with Alex Brown, a division of Raymond James, and Joseph Solito, who's an attorney with Page, Scranton, Sprouse, Tucker, and Ford PC. We always start by having our guests tell us a little bit about themselves and their practice. So Chris, if you would start.
Thanks, Leanne, and thanks, Craig. So I'm with Alex Brown, which is a division of Raymond James. And, we provide financial advice to individuals, families, institutions, and it's really comprehensive financial advice in which we're quarterbacking basically, everything personally, financially for individuals and families. My background is I'm actually a graduate of Georgia Tech. I graduated with a degree in electrical engineering. Was an electrical engineer for a few years and then went to business school and then graduated from business school from the University of Georgia, and I got into wealth management. I was with Genspring Family Offices before initially, and then Goldman Sachs after that, and now currently with Alex Brown.
How about you, Joseph?
My name is Joseph Solito, and the law firm that I'm with is known as Page Scranton. It's been in Columbus for over 100 years. It's a full-service law firm, and I've been with the firm since I got out of law school in 2001, graduated from Georgia State. My practice is trust and estates work, probate, guardianship, things of that sort. Before graduating from Georgia State, I went to Vanderbilt, and my wife's a lawyer, got 2 children, and happy to be on the radio show today.
Thanks for coming, guys. Let's start off really and jump in easily. So, Chris, why don't you tell us, I love your phrase quarterbacking. Tell me what is a financial plan?
What's a financial plan? Well, think of it as it's a document that it does 3 things, right? So the first thing is that it provides a snapshot of your current state of affairs. So what you currently have financially, so that's assets and liabilities, cash flows. And then the second thing it does is it provides, it kind of articulates and formalizes several financial objectives or goals. And then the last thing it does is that it implement strategies to achieve each individual financial objective or goals. So, it's really just it's a blueprint basically to help folks understand where they're at, where they want to go, and then ultimately how to get there.
How is a financial plan different than an estate plan, Joseph?
Well, the financial plan is such a huge help in doing an estate plan, because you find that so many people don't really know or haven't thought about in a while maybe exactly how something's titled. Maybe they know more about what it's worth, but the financial plan helps with the numbers and helps generate some tax advice. But it, first and foremost, lets people take stock of what they have, how is it owned, does it have any sort of beneficiary designation, or or any TOD or pay on death type thing that would really come into play when we do the estate plan, because the estate plan is a way to manage those assets during life, but mostly how are those assets going to be transferred at death. But knowing how they're titled, knowing what they're worth is having that financial plan is a big piece of having an estate plan that's actually worth something. So many people come to me and say, I just need a simple will, or I want it to go in a trust for my spouse, but without knowing more about what are the assets and how do they move on their own, you might give a will or prepare a will that really doesn't do much of anything because all of the assets are owned in a joint account, or the majority assets already have a beneficiary designation to someone else even, or maybe even to the spouse, which is fine. So they go together very well. They do two different things, but they're very helpful.
I would say, I'm sorry. I would say that there's differences. There's also similarities, right? The purpose of having a financial plan is ultimately to create clarity, right? Clarity around what you have, where you're going and how you're going to get there. And the difference might be in just the timing. So the financial plan is really more about your monetary objectives during your lifetime and when you're fully cognitive. And the estate plan is something that actually it's not mutually exclusive from the financial plan. In fact, there's a ton of overlap. But ultimately what that does is it creates clarity around what happens should you become incapacitated or upon your death. So I think both of them, the purpose of them is ultimately to create clarity, right? And I think that's what I tell clients always is, whether it's an estate plan, a financial plan, or your New Year's resolution to be healthy or lose weight. I mean, you want, number one, the goal is to create clarity around where you're at, what you want to get to, and I think the more specific you make those objectives and those goals, the easier it is to reverse engineer how to get there, and also the more likely it is that you maintain discipline to achieve those goals.
Well, as your life changes, I imagine you need to review your estate plan, and as the economy changes, you would review your financial plan. Is that accurate?
Yes, sure. Some people say every 7 years. I've heard every 5 years. Certainly, anytime there's an event, whether it's a birth or a death or a marriage or something, big's happening in the economy, there's a lot of good reasons to look at it. But putting it on a calendar, every 5 years seems to make sense. But it's really hard to go. It's really hard to get a plan that's going to last you your life. And so many people, I end up telling them, don't let, what's the phrase? Don't let the perfect be the enemy of the good. If we can just have some plan, you're going to be just a quantum leap ahead of where you're at. So maybe we get closer to perfection 5 years from now, but just do something and then make it better later. Right, Chris?
Yeah, I would agree. I think that for the most part, a financial plan should be pretty stable. And there are certain events such as birth, death, marriage, or maybe even the anticipation of marriage, or divorce, or I guess the anticipation of divorce, that may alter the financial plan. But they're all long-term goals, and so you have to have a long-term focus and not let the noise of a bad economy or bad equity stock markets alter your course. But it's helpful to have that financial plan there, so that way you understand, okay, well, you understand the levers that you can pull in different situations. So you basically have preparing for curveballs that life will throw.
Joseph, you mentioned something that I think is important, and Leanne and I see it all the time when we get to disputes. You said one of the things you always want to check is how things are titled or why they have beneficiary designations. Chris, when you're looking at a financial plan, do most people actually understand how things are owned or titled or designations, or is this a problem you're seeing as an initial step?
No, I don't think many people understand it. Well, I think people understand it, but they don't. They may not, execute it. So I think that the titling of accounts, and it really needs to align with what your trust and estate plan is basically conveying. So you just want to make sure that whatever your intent is, whoever your intended recipient is of the accounts, contingent, primary and contingent, that it actually is going to go to them.
Joseph, answer that. So you mentioned that a will obviously transfers property at death, but it's only the property you own. But when we talk about designations, and you mentioned a TOD, transfer on death, but there's also joint accounts people can write checks on. How does it fall in when you're looking at an estate plan? How much really is actually being controlled by the will, and how much is kind of being controlled by other factors?
Yeah, it depends. Sometimes a vast majority of the estate could be controlled by other factors. And sometimes that's fine, but often it's not. And, the probate estate is what you own that is controlled by your will. And then the non-probate estate is what you own that's controlled by some other means, whether it's a beneficiary designation or joint ownership with right of survivorship, they call it, meaning the last person standing gets it. The last one alive owns it. So, typical spouses, there's a lot of joint ownership and beneficiary designations, and that's fine. Where it ends up being a problem, or can be a problem, is when there's one spouse alive and there's children, and so maybe one child gets named as a joint account owner for whatever reason, and it was probably out of convenience or check writing capabilities. And then at the end of the day, what was always understood to be a kind of a friendly, help me write checks type arrangement turns into, well, mom put me on this account, so surely mom wanted me to have it at death. And the banks don't get involved. The banks just do what the documents say, or the life insurance company doesn't care what the will says. If one person's named as beneficiary, then that's going to control. So what a lot of people do is they don't rely on the powers of attorney. And that's what I try to tell them. If you want your daughter to help you write checks and look out for your financial things, do a power of attorney and trust that. You don't have to put your children on accounts with you, despite what the bank may say, despite what makes it easier maybe for the bank. A power of attorney is what is needed and what should be relied upon to do those things.
And let's highlight that. If you go to a bank and say, I'd like to help my mom write a check, they're going to put you in a joint account with right of survivorship. That means that you can use the account for anything while your mom is alive, and then you get it at death. But you could actually ask a bank, it's called a power of attorney account, a POA account, that only lets you sign under authority. And I want to highlight something that we're seeing. This also applies to caregivers. It's not just family members. And Chris mentioned dissipation of marriages. Dissipation happens in lots of ways, not just divorce, sometimes death, but sometimes estrangement or separation for whatever reasons. And so you're going to have often blended families, different people with different relationships. So it really is important to understand who's controlling what. Chris, let me ask you a question. What types of things, you talked about having clarity as to what you own. Mm-hmm. What types of things are in a financial plan? Is it just where you've invested your money, like in a brokerage account? Is it businesses? I mean, what are the elements of a financial plan?
The more detail, the better. So, it's often, here's what I own currently, and that can be checking account, investment accounts, 401ks, IRAs, Roth IRAs, and also 529 plans, UTMAs. It also includes your personal residence, any investment properties that you may have, but it also includes your W-2 income, right? So your earned income. All of that is, they're basically inputs into the financial plan. And when I said the more detail, the better, it's because the more detail that you provide, the more information you provide, the more specific you provide the information that's provided, the greater clarity you have in ultimately reverse engineering how you get to your objectives.
And when you talk about objectives, are we talking about tax planning? Are we talking about retirement planning?
It's retirement planning for sure. I think that's probably one of the biggest uses of financial plans. And basically what it is, you say, look, you make an assumption that you're going to live until you're 95 and you're going to retire at 65, or you want to retire at 65. So how much money will you need, to retire at 65 in order to keep you, through to 95, right? And maybe at 95, you also still want to have some assets that you can bequeath to that you can, give to your children or whoever. And so what you're doing ultimately is saying, okay, well, how do I get to that number at 65 while right now I'm at 40? And so, tax planning is certainly a part of it, but retirement planning is, that's usually the main purpose of a financial plan, but it also could be college planning. So in 18 years, I'm going to need this much money to put my kids through college, or this kid through college, assuming they don't get a scholarship. And there's a lot of assumptions. Obviously, there's a lot of noise, but they have 18 years to get there. How do I get to that number starting today? And so that's what a financial plan incorporates. And so that's why there can be several objectives. It can be retirement planning. It could be tax. It could be college planning. It can be philanthropic planning. And so it all is part of it. Tax planning is what is used to help determine how you're ultimately going to get to those numbers.
Joseph, how do tax planning and philanthropic planning play into estate planning?
Oh, yeah. Those, the estate tax, people think about, well, I don't really have an estate, or I don't have enough money to worry about the death tax or estate tax, and so therefore I don't need an estate plan. But, there are a lot of taxes to be concerned. There's plenty of taxes to be concerned about, even if you're not necessarily worried about the estate tax. So income tax issues and charitable deductions, which affect the income tax, or whether you're just charitably inclined, regardless of the tax ramifications or benefits. Both charitable planning and income tax planning would be part of something that you might just refer to as an estate plan. Because when you want to make a gift, or you want to create a trust or a will, that all just comes under the idea of an estate plan, but it may have different tax objectives. It may not have any tax objectives at all, but it's certainly the case that the income tax is going to affect everyone, while the estate tax affects very, very few. Another big point that people ask me a lot is, what about when I receive an inheritance? Do I have to show that on my income tax return? And, generally speaking, what you inherit is not taxable to you. Now, the earnings it makes, or the interest, the dividends, something like that, now, or the income, the last income of the deceased may flow to you, but by and large, what you receive is not income to you. So that's a common tax question a lot of people ask. The other one they ask is, well, what is my tax basis in my inherited assets? Like if you inherit some Coca-Cola stock, that your mom bought back when it was $20 a share. The good news is, at least under current tax law, you take what's called an adjusted basis or a step up in basis. So if you inherit something at death, through death, you take a basis equal to the date of death value. Whereas if you take an asset from mom through a gift, she gives you her basis, which could be a very low basis. So when you turn around and sell that Coke stock, you may realize a lot of gain, where if you could be patient, let's say, and wait, you get that basis. Now, Congress is always talking about maybe changing these basis rules, but those are the two big tax things as far as estates that people come across.
Thanks. I just want to take a second and remind our listeners that you are listening to Wealth Matters, the radio show where we discuss the opportunities and challenges of preserving and managing wealth. We are your hosts, Leanne Gilbert and Craig Frankel from the fiduciary litigation law firm of Gaslowitz Frankel. And we are talking with Christopher Shirky, financial advisor with Alex Brown, a division of Raymond James, and Joseph Solito, an attorney with Page, Scranton, Sprouse, Tucker, and Ford PC. And our topic today is financial planning in today's unpredictable world.
Joseph,
Craig?
I wanted to follow up on what you just said about tax planning, where you deal with income tax focus. I know that a lot of people don't follow that. Should you in your estate plan and in your financial plan be revisiting this from time to time, the tax focus on what is my tax basis? When am I going to be taxed? Should I change things? Can I change things even if it's a trust? How often should you look at that?
Gosh.
How can you look at that, I guess, is a better question.
Yeah, as often as Congress seems to want to tinker with it. So it's right now, and in the past 10 years, it's been it's been a hot topic. And so, politically, the estate tax is of interest. Now, it's not a big revenue raiser for the federal government, but it is kind of a political issue in that people feel like the wealthy should pay their share. So with the estate tax affecting fewer and fewer people, which means the estate tax exemption is getting higher and higher, it does cause you to focus more on income tax issues. Before, we may have put things in trusts to hide them from estate tax, to hide them from future estate tax.
Hide is such a strong word.
I love that word, hide it. We're hiding it. The federal government has enough money, but now, or as the estate tax changes, instead of hiding, we possibly would expose assets to the next estate or to estate tax, because in exposing assets to estate tax that we know we won't pay because the exemptions are so high, we are actually getting a benefit on the income tax side. So trusts, for example, that were designed to keep assets for the benefit, let's say, of a surviving spouse, but then not let them be a part of the surviving spouse's estate. We're changing those trusts as we draft them going forward, or we're putting some contingent language in them to say, gosh, if we don't need to worry about, in effect, if we don't need to worry about the estate tax, let's go ahead and subject these assets to the estate tax so that we can get that step up in basis that we need.
I want to remind our listeners that although we're broadcasting from Georgia, and Georgia does not have a state imposed estate tax, other states do. And so sometimes we've got to look at that. And that really brings me to the next question for you, Chris. Are you finding that clients who have some wealth, that they own assets in different states? And how does that affect a financial plan?
It doesn't really affect the financial plan. So yeah, most of my clients have assets in different states. It really affects it if they spend 183 days a year in Florida or Texas, right? I mean, that's ultimately where now they're saying, okay, well, I live in Florida, but maybe their assets outside of their state is actually in Georgia, right? So their site is in Florida. Florida residents. But it really shouldn't affect a financial plan, because ultimately you're just trying, the financial plan is focused on monetary targets. So it really doesn't affect the financial plan. It certainly affects the estate plan. And the tax planning is really more about where your declared state of residence is.
Joseph,
Yeah.
do you find that people who move to Georgia or away from Georgia, they may have been in a community property state, now they're in a different type of state if they're remarried? If somebody moves to Georgia and they've already got estate planning, whether it be a trust or a will, does that change when you move to Georgia? Do you need to revisit it, or is it something that pretty much can go anywhere in the country?
Well, I think it's worth taking a look at, but you'll probably be fine. I don't believe there's a state in the country, for example, that has a different witnessing requirement than 2 witnesses to make a will. So I think you've got a will, or let's say you've got a living trust and you come to Georgia, you'll probably be fine. It does not hurt to have that looked over. But one thing I will say about folks that come here or folks that have property in other states, those that come here want a living trust, or those that look out and Google things and try to get up to speed on wealth matters, they will come to me saying, I need a living trust. I need a revocable trust. I need to avoid probate. But it's very true that in Georgia, the probate process is not difficult. It's not something to be avoided. It's not something that the costs of which are dictated by the assets in your name. So now Florida residents, yes, the probate system there is to be avoided. And so, and most of what you see on the internet talks about that, because maybe Georgia is an outlier, but it is true that that probate avoidance is not something that kind of runs the show here in Georgia. That's not to say living trusts don't have a use, because if someone is a Georgia resident but has property in other states, for example, Florida, or really any other state, you can really simplify the probate process by at least having those assets that are in other states owned by a trust, so that you can avoid that state's probate process. There's a lot of other reasons to have a living trust, but when someone has property in other states, that's kind of a clear signal that you may benefit from not only a will, but also a trust.
What is a living trust?
Well, living trust is just maybe another name for revocable trust. It's a trust that handles your assets, manages your assets, holds your assets while you're alive. So I guess that's where the living part comes. But it can also serve as a will substitute in a way. It can also serve to govern the distribution of your assets at death. So you could just have a living trust and not have a will. The issue with that is you need to be sure that all of your assets have been transferred to this living trust while you're alive, because otherwise it won't be able to be handled at death. But it's a great management tool. For example, if you don't have anyone you trust to be your power of attorney and help you with financial things, but you have a good relationship with a bank or some corporate trustee, transferring assets to a living trust and naming that corporate trustee as trustee would allow you to have someone that you trust to help you while you're alive with your financial affairs, check writing, management of assets, whatever it might be.
And that might be very helpful as you watch and as you age, that someone has experience with your financials as you get older and then can take over. But you highlighted something, someone you trust. Chris, do you find that your clients easily find somebody who could serve as a fiduciary, someone who could be that agent for a power of attorney? Or is this a difficult issue for your clients?
Yeah, for the most part, I think they don't have a problem finding someone that they trust or that can serve as a fiduciary. If they, of course, you could have a corporate trustee, for instance, And there's benefits of that, right? Because someone that you trust today may not be someone that you trust later, or they might not also be around later. So, but in general, our clients don't have any difficulty finding someone that they trust.
When your client finds somebody that they want to be their fiduciary, Chris, do you then sit down with that person and explain your client's financial plan to them, or do you wait until they're needed to step in?
Yeah, it really depends on how much leeway the client provides, right? So confidentiality is, we're pretty maniacal about that. But in general, the more information that they have, the better that they can prepare. Or at a minimum, if they at least know, okay, well, I'm to reach out to Chris, and he's the person with, all of the information, then it just makes it that much easier.
So let's follow up on that. So you were very diplomatic, and so was Leanne when she asked the question. How many people of your clients actually let you talk either to the fiduciary, or you mentioned earlier the family, or are people more like traditional, like my parents, who never talked about money? So how many people are willing to talk about it to either the other financial planners or advisors and their own family?
I really push that. And that's because the sooner the children know, right? Especially the children, the sooner they know, I think the better, right? It shouldn't be a taboo subject. Instead, they should understand, the use of, not only obviously what amount there is, but really more importantly is, what's the point of having money, and all of the risks and sacrifices and discipline that was needed to accumulate this wealth, and so therefore you attach some level of meaning to it, and then maybe even your expectations of how the children would use this wealth, right? And that even shouldn't be a taboo subject. At least you can have a negative screen of saying, I don't want you using this money for this. I'd rather you use this money for this. And you can put some language around that in a you can put that in a trust, right, with HEMS clauses, healthcare, education, maintenance, and support. But ultimately, the sooner they have that understanding of everything from what your expectations are to how it was accumulated, and all of the hard work and risks and discipline that was needed to get there, the sooner they have an appreciation for the money.
So essentially, Chris, you're being diplomatic too. So that's the goal. Joseph,
Yeah.
How successful are you at getting your clients to actually do it? Tell their children, here's what we're doing.
Yeah. No, I don't. You don't see that a lot. At least I don't. The high net worth folks, too, of course, that's a real struggle. So very wealthy folks, that's a real struggle for them. Try to decide when and how much should a child know. Of course, there's books upon books written about that. And but your original, or part of your original question was how willing are clients to maybe talk with a broader team, or talk with their future fiduciaries, or let them know. I see a lot of that, no matter the wealth. Please talk to my CPA. Please talk to my financial planner. Talk to my banker. Let's get all on the same page. I want to be sure. And then some folks like to talk early to their future power of attorney, or their future executor. And then some people ascribe to the idea of, well, if I ask them if they want to serve, they might tell me no. And if I didn't ask them and just name them, when the time comes, they'll just do it, out of a need. And so I'm going to go ahead and name them. So you do get some of that camp. I know that doesn't maybe directly answer your question, but I always find that interesting that there's two camps. Some people like to give permission, and some people just ask for forgiveness, because it can be somewhat of a thankless job to be an executor or a trustee, even if you are paid some compensation. It's a lot of drama and stress, and back and forth. you're the gatekeeper. And then power of attorney is can be difficult on its own as well. It can be a very long-term job. But no one has to be an expert. There's always people to help, accountants and brokers and financial advisors. And so that's good. Anyone who's in a role like that, or anyone who's struggling to figure out who should be named in that role, keep in mind that the person does not need to be some jack of all trades. They will get help from a lot of people. First and foremost, it must be someone you can trust. And if you don't have that trust, then that's why there are corporate folks or professionals that are in the business. And I find more and more that that's being more and more necessary. Just maybe it's because people are living longer and they need assistance longer, and so the job takes a long time, or people are realizing the power of trust and the usefulness of trust, whether tax planning or otherwise. And so it's a long-term job that's maybe better left to someone who's trying to do that for a living.
I think we need to underscore the change. I think that the demographics of aging, where our parents are living a lot longer, and therefore, and our health system, where we're spending a lot more money, changes things. And as our children also move around the country and aren't with us, that the financial needs of our parents, not only do they change, oftentimes there's less or different wealth. And so Chris, are you seeing families come when they're nearing retirement age and saying, 60 or whatever, and saying, maybe I should change what I am doing? Are you seeing people coming to you then, or are you finding people coming to you hopefully earlier?
Earlier, but that might be just a product of the client base. So most of my clients are private company business owners who are thinking of an exit, or maybe there's already kind of an immediate exit in the near future. And it generally happens before they're in their 60s. I mean, my client base tends to be, not much younger than 60, but in the 50s. So I think that I don't think that they should. I don't know if it warrants a change. If you get older, you decide, well, I need to change what I'm doing, unless what you're doing is just ineffective, and you want something better. So yeah, it's tough. It's tough to answer, question to answer, because I just feel like most of my clients are folks that are private company business owners. There's an impetus for them to reach out to me and change their plan, and a lot of times it's just because there's going to be significant wealth created from an exit.
You talk about an exit, and Joseph, you and Chris can answer this. Are your clients coming to you in advance to say, how do I transition this business either to the next generation or to a sale? Or are you finding that they come to you, unfortunately, afterwards, when something's already happened and you aren't able to plan it? How is that playing out in the real world?
I think some of each, but I think folks like Chris, they probably get more front-end talk than the lawyers. It just depends on the relationship. I personally don't have a lot of clients like that are business owners that are coming up with a sale or something, but it is true. It's a shame whatever the event. I feel like for the most part, people are coming in at the end, but I would bet Chris would say he's got good clients that think, let's talk about this before it happens.
Well, they just have a good advisor that tells them that. I'm just kidding. So
no, you shouldn't, kid. That having an advisor along the way is really important.
It is, and I think that it's, if they're clients of mine already, then that's going to happen for sure. I mean, I always tell folks that own private businesses or just a business, there's always an exit, whether it's to wind it down or to sell it or to transfer it to the next generation. I guess the only other option is to go bankrupt, or to go under. But so if they're running their business, that that should be a plan that they have in place from the onset. And it doesn't have to be implemented immediately, but there's got to be some, plan in place where, it's very clear. Okay, if I get to a point where I decide I want to engage with an investment banker because I want to sell my company, or if I get an unsolicited offer to purchase my company, and there's a lot of important reasons why you want to have, you want to be engaged with your estate attorney right before there's a letter of intent on your company.
Okay, so we're getting towards the end of the show. I'm going to put you on the spot, and Joseph, we're going to start with you. You have a potential client. What's the advice that you would give, the one advice to your potential client? What do they need to do most?
They need to think about, do they have those kind of 4 documents, or you might even get away with 3 documents that almost everybody needs, I would say, which is a will or some sort of trust or will, a power of attorney for financial things, and a healthcare power of attorney or advance directive or living will, you might have it referred to. So those 3 documents is kind of the basic first step, and that can really serve you for a long time. Whether you become incapacitated or whether you pass away, you've got something in writing that handles those situations. So that's the first and foremost for most people that I talk to.
Okay, Chris, you get the chance. Advice in advance to your client. If you could tell them anything before they came to you, what would it be?
It would actually be to talk to folks like Joe. Because I really do think that having those documents in place, right, the will, advanced medical directives, durable power of attorney, is probably the most important first step. But the advice I would give them in addition to that is you really need to have a team that you have a lot of confidence in. And that team should be comprised of, your financial advisor, your legal advisor, your trust and estate attorney, your tax advisor, your accountant, and they all should be your insurance advisor. So they all should be working together, right? There's likely one that ends up quarterbacking the relationship with the client, but that is your team. And in addition to that, and this is something that I harp on a lot as well, which is you need to consolidate information, right? So, we have what is effectively a digital Dropbox in our client web, and I tell clients, upload your trust and estate plans, all of your legal documents, even tell clients if they have LLCs for specific real estate investments, upload your operating agreement, your EIN numbers. But the financial plan will also capture almost everything of what you own. But having that all in one place, having all that information in one place, should, God forbid, the worst happen, will give you, it's just a huge, burden off your shoulders, because you then know, well, if something happens to either me or both me and my spouse, then for sure there's one place that at least most, if not all, of the information can be accessed.
It's the bottom left drawer of my office. You didn't know that?
No, it's
All right.
Always good to have a backup.
Before we wrap up today, Chris and Joseph, if you would just let us know how our listeners can get in touch with you if they want to find out more about you and your firm, starting with Joseph.
Well, you can call me directly at 706-243-5631, and I'll be there to answer it. And you can call me as well, 404-442-6766, or you can go to alexbrown.com and find your way to the Atlanta office and look for Christopher Shukri under team. Yeah.
I want to thank everyone today for listening to Wealth Matters, where we discuss the opportunities and challenges of preserving and managing wealth. For more information about Gaslowitz Frankel and our guests today and on other shows, please go to our website at gaslowitzfrankel.com. And remember to follow us on Twitter at Estate Dispute and use our show's hashtag Wealth Matters. Our guests today were Christopher Shukri, a financial advisor with Alex Brown, and Joseph Salito, an attorney with Page Scranton in Columbus, Georgia. Please join us every fourth Wednesday of the month at 8:30 a.m. here at Wealth Matters on Business Radio X.